Well, all right, it's 12:02, and I think we'll get started. Before we even go ahead and introduce ourselves, we'll get some of the disclaimers out of the way. This is attorney advertising, and nothing that we say today should be construed as legal advice. You should always consult with counsel when you're looking for specific legal advice. Of course, we recommend ourselves as the very best out there. And nothing that we say today should constitute the formation of an attorney-client relationship. Although many of you wonderful, handsome, and lovely people out there listening are already our clients. But if you're not, you should consider it. And I guess without further ado, we'll get right into the presentation. My name is James Cousins, and you guys will all, and guys and gals will all remember me having done this for many years in the past. And I'm again joined by my friend and colleague, Brendan Shannon, who has assisted us this year in putting together today's lovely presentation, which is the big one, folks. This is the big one. This is the Super Bowl of OMAD presentations. We'll get here every year, even if the Bills don't, unfortunately.
Too soon.
I know, too soon, sorry. And this is our 2023 case law update. And this year, we had a lot of great rulings. And I want to let everyone know that early next week, we'll put the finishing touches on the written copy, which is right now sitting at 93 pages. It discusses every decision that came down from the Appellate Division with commentaries from myself and Brennan and other members of LOMAD that provide insight and, I guess, guidance on how those cases are important to us. So we're going to jump right in with the biggie. This is the big one. This is Green v. Duchess County. We watched this case go up with bated breath because we saw the Appellate Division's ruling, which we all hated. Short story, some smart lawyer managed to convince the Appellate Division, wrongly, that a claimant who had a balance due on their cap, who died, was able to shunt the rest of their remaining cap to their decedent, to their dependents, or to those who would otherwise step into their shoes to collect a posthumous cap. They tried to make the analogy to make it sound like posthumous schedules, which we all know you can get with certain limitations. Thank the maker, though, the Court of Appeals did take this case up and did, in what I would consider a rather scathing decision, repeatedly and in many different ways, tell the Appellate Division how they misunderstood, misread, or otherwise had no idea what the law below said. And they simply pointed out that there was no mechanism under the law whereby a schedule was designed to be treated or intended to be treated the same way as a non-schedule award. And there's no mechanism under the law whereby a posthumous non-schedule award could be collected by the folks that survived the decedent. And as a result, we finally got the ruling that we'd all been hoping for from the Court of Appeals on the Green case. So thank the maker. I know several of our attorneys actually had cases sitting in stalled litigation where claimants had raised this issue. And thankfully, this case came out and killed all of those claims. What's our next one? All right, Jennings. Jennings I want to talk about because Jennings is an outgrowth of Jacoby. If you remember a few years back, Jacoby came out and provided mechanisms whereby post-permanency claimants could receive temporary total disability benefits. None of us liked that. We didn't think it made sense. It seemed to throw a huge hurdle in the way of actually bringing finality to these claims, which is what the 07 reforms were designed to do. Now we've got Jennings, which says that not only can you collect temporary benefits during the pendency of a cap running, you can collect temporary benefits after the cap has completely run and expired. What's interesting in this case is clearly the claimant didn't qualify for potential reclassification under Section 35 and maybe hadn't even yet had evidence of a change in condition, right, which the third department talked about last year, where they said just having surgery doesn't mean that you got worse. You need evidence of a return to baseline or to have reached MMI after that surgery before the board should really be considering what to do with your permanent disability at that point. So now we got Jennings, which seems to suggest we could have a lot of TTD or a lot of TPD on certain cases. There are a lot of files floating around out there where claimants were classified before they had surgery. So Jennings is not what we wanted, but it's what we're going to have to live with.
Yeah, that's a frustrating decision, James. All right, next up.
All right, this is the last one where you're just going to hear from me in a row. The Samanski case. We wanted to highlight this one for all of you in the audience because it's a common fact pattern. You have a decision regarding a schedule below, and it's subject to an appeal. During the appeal under Section 23, we do have a stay of awards. Now, the board has consistently issued case law saying it is proper for the employer to make payments for that amount of the award that is not disputed. And that is our usual recommendation. If we're taking a case up on appeal and there's a portion of an award, be it a schedule or anything else, that is not disputed, you should make that payment and withhold everything else that might be subject to a dispute during the pendency of the appeal. What happened here was that there were issues that affected the entirety or the whole overall value of the award, including potentially minor's wage, PHP, and other things where it wasn't clear how much the claimant was going to be due. So the employer elected to withhold the entire award. The board didn't penalize the employer after the appeal came back because they felt that they withheld the award appropriately, and the claimant sought panel and third department rule trying to get this penalty. And in both instances, they lost. So it's a good case that could be expanded if you happen to be in a situation where it's questionable about whether you should have paid the award or not. Samanski does have some pretty broad language in it about our right to withhold. So good practice development for those of you out there that might find yourself in this situation.
All right, so next up, we've got the Kingston decision, which involves the issue of appellate practice. So this is a case where there was a reopening request after an SLU award had already been made. Now, in such a case, what needs to happen is that the treating doctor needs to file what's known as a C-27, basically explaining how the claimant's SLU now exceeds what it was at the time of permanency. And what was notable in this case is that the doctor stated that the claimant had the same symptoms and complaints as he had at the time of his initial SLU opinion, and this was during a deposition. And what's really notable here is that the doctor also conceded that he had contemplated some deterioration from what he was finding at the time of permanency the first time around. So basically, the deterioration that was being claimed on the C-27 had already been considered at the time of the claimant's initial awarding of an SLU. And basically, that was found to not be sufficient to justify a reopening for further consideration of whether the claimant's entitled to, additional money moving as the result of an increase in a prior SLU award. All right, James. Next up, you've got Olzewskiski.
I always say Olzewskiski because I know somebody whose name is spelled this way, and he said it's Olzewski.
As soon as I said it, I knew I was wrong.
No, that's all right. So we like this case and we present on it today because it is not uncommon that an appeal in traveling files is taken and it implicates both files. Now, there were all kinds of problems when the board started the 300.13 nonsense, and there were all kinds of scanning vendor problems about how to get the appeal once into each file without getting it duplicate filed in one case and not filed in the other. Now, the board, after seeing all these issues, issued a subject number providing guidance about how to get duplicate files, essentially duplicate appeals filed in traveling or companion cases. And it has to do with circling the stuff on the one and making sure the subject line of the email filing it, etc. The subject number says that if you screw around with this or get it wrong, you could be penalized. What the board did here was they denied review altogether and said you filed it in one case, but didn't file it in the other. And therefore, we're not going to review this altogether. And the third department came down and said, well, we read your subject number, folks, and it doesn't say that you're going to deny review. It says you're going to penalize them. So they reversed this and remitted it and said the board had to consider the appeal on the merits. It also seems like it would be an issue that 23A might apply to, where the board might say, hey, we've got it in one case, we don't have it in another. We'll deem it timely filed. There must have been some kind of weird error in the filing, so refile it in the other case. That's questionable. We said last year when we talked about 23A that we felt that anything that was substantive about filing or timeliness was probably not going to be given any relief under 23A. This is one where it might be. So
Yeah.
Good practice. And you know what? I can probably envision lots of appeals in the past that sat unreviewed and were denied appeal and didn't go up on this issue. So in the Olzewskiski case, whoever litigated this gets kudos for having taken the time to carefully read what subject number 46-1106 said. Right? I mean, that's what most appeals boil down to, right? It's actually reading carefully what the law says.
Yeah, James, I tend to think that 23A would apply, so it'll be kind of interesting to see if that'll come up at some point. All right, so next up we have Pierre, and this is a very notable decision involving COVID. So it's sort of the first third department claim that we've seen addressing the issue of how a COVID claim is going to be handled in comp. Now, one thing that we've sort of taken umbrage with here is that the board basically made this prevalence standard of its own volition through board panel case law. There was no statute or amendment to the statute or the regs. And this is the first decision from the third department discussing the issue. So it was very frustrating having to sort of work within these nebulous constructs when litigating COVID claims. Here, what's notable, so the claim was established and it's affirmed. What's notable here is that the court doesn't discuss the prevalence standard specifically in their decision here, but the analysis by the third department was sort of functionally the same as the prevalence standard, which leads us to believe that we're stuck with the prevalence standard that the board sort of made on its own. I think there will be more litigation on this issue, likely sort of solidifying what the standard is for a COVID claim. But as far as the decision in Pierre goes, the prevalence standards appears to be here to stay. It wasn't, struck down by the third department. So would you agree, Jan?
Didn't they kind of go out of their way not to say the word prevalence?
Yeah.
It leads
Sorry.
me to.
This is Melissa. I just wanted to pipe in and just say, they didn't strike down the prevalence standard, but they also didn't employ it.
Right, that's true, but their analysis was pretty darn close. Our problem with this is that one of two things is true. Either COVID claims are treated differently, which is what the board said when they established the prevalence standard. They said, we have to employ a different standard to establish these claims because otherwise they would probably not be established. Then the third department says, okay, this one's fine under your ordinary standard or
right,
not.
That's the way I'm reading it.
Right. Mm-hmm. So I guess maybe this one was that good, but not having seen the briefs, I would still guess that appellant's brief in this case was probably ad nauseum about how the prevalence standard is inappropriate. And it was probably just all dismissed as irrelevant in those final sentences to the extent that the carrier raises other issues not herein addressed. They're deemed to be, without merit.
Right.
There you go. Right.
I mean, and the facts in this one were, consistent with what the board would consider to be prevalence. It was, upwards of 10 plus employees or something like that. A very high number of employees all tested positive at the same time. They continued going in and having in-person meetings once COVID had started, like shortly after COVID began. So I think that's where you get the idea that it seems like the third department's sort of not taking issue with the prevalence standard.
Well, I mean, you can bet your boots that every board panel ruling that talks about prevalence from now on is going to cite this case for the proposition that it was affirmed. Right. Yeah. I mean, they're just going to say that. Oh, well, we all know better. Yeah. We all know better.
No, I think there's still hope with that issue. All right.
So, yeah, this is, I only want to talk about this case. I almost don't even care what this case is about. What I care is that this is one of a bunch of cases this year that cites Fox v. Altamar Parish and reinforces it. I actually call this 2022 is the year of the fox. That's the Chinese kid. No, it's the year of the rabbit. Might be the rabbit this year. Whatever. It was 2022 is the year of the fox. Plenty of cases came up on causal relationship where smart, sophisticated, good-looking clients, employers, and their counsel said, I looked at the claimant's medical and I think it's crap. I'm not going to get an IME. All I'm going to do is challenge causal relationship by cross-examining the doctor and finding out what they know and what they don't know, what information they've looked at and what information they haven't looked at. And the third department and the board, much to the board's credit, is very happy to discredit a treating doctor who hasn't looked at prior medicals, particularly pre-existing condition ones, where they haven't been given a complete history of the accident, and as we'll look at later on, where they may not know what the claimant does for a living. So if you can, even if you get good testimony, right, you sit through the deposition and you say, boy, that doctor really did sound persuasive. But buried amongst that is the doctor's concession that they didn't look at any of the prior treatment records on this claim. They were unaware that the claimant had a pre-existing condition. They did not look at those records. They are not aware of what the claimant does for a living, and they're not entirely sure what the mechanism of injury was, or if the claimant gave a different one, they've never heard about that before. No matter how persuasive they sound, you have a killer, spear tip sharp argument to destroy that doctor's testimony. And that happens fairly frequently at our office. I just had it happen last week. Brendan, you probably had it happen at least this month. It happens regularly. These doctors know how to testify and come across as suave and confident in their opinions, while at the same time, they say stupid stuff that kills their opinions. And you have to be able to look past their presentation and dig into the meat of what they say, because the judges aren't hearing the testimony, they're just reading it. So they're great quotes. No, I don't know what the claimant's mechanism of injury was. No, I didn't know that the claimant told another doctor something different. And by the way, I haven't seen that doctor's records, right?
Yeah.
You don't even necessarily have to ask the next question, because before the Fox case, we all had to ask the next question, which was, now that you've heard this information, would it cause you to change your opinion, right? And that was always fraught with danger, because the doctors usually say, well, not really. And then you kind of feel like you're hung. Now we don't have to ask that question. All you got to do is poke holes in their actual knowledge of the history of the case, and then you're done and walk away. I love it.
And James, what I think is notable too, there's a lot of decisions on this issue this year, because I think even though the board seems to be getting it right, judges don't get this right. Judges are not very receptive to this issue. They seem to basically ignore it usually, which leads to a lot of appeals to the board, and lo and behold leads to several decisions coming down from the third backing up our position, hopefully making it so judges will start to be more receptive.
Right. Well, it requires them to read deposition transcripts, which we know a lot of really don't like to do. And if you don't read a deposition transcript and all you're doing is relying on the briefs, you're going to get it wrong.
Yeah.
You got to look at that transcript and decide, wow, did that doctor really admit that they've never looked at the prior medical records, and that the IME did, and the IME came to a different conclusion? I think it's a great case. And I think this is Fox. I have said for years, as much as it may seem like one of those lame Ben Stein kind of issues, Fox was going to have a long-standing impact on the defense bar. And I think we're starting to see it now.
The other thing, one last point too, it doesn't even matter if the IME doctor reviewed it. Sometimes these records aren't available or whatever. It's not our burden, right? So if there's now no credible medical evidence on causal relationship because neither doctor was able to have access, that's very common too, where maybe we've been requesting it, trying to get HIPAAs, you name it. We can't get a hold of these prior records that we know exist. That's not our problem.
Yeah, and by the way, the facts of this case are really cool, because it was like a dean, like a senior dean at Long Island University, who was being super shady through this case. You'll see the last couple lines of our squib talk about how the third department on its own kind of was like, the claimant's behavior here seems kind of sketch and fraudulent. Like when you read the whole decision, it's pretty clear that whatever this person was doing was shady. So it was kind of funny,
Yeah.
because like, what was it, like 2 years ago, there was the disability judge that got claimed to have gotten squished by the closing elevator doors. And then they caught her, and then it was a huge lie that she had been injured in any way. Yeah, I kind of thought about that case when I read Yearwood. Sorry, I just like to ramble because I'm seeing connections here.
No, Yearwood's a good one.
Yeah.
All right, so the next one we have is Banish, which involves the issue of collateral estoppel, which, for those of you who don't know, is basically just this idea that a decision in one court has a preclusive effect in another court. And here, the claimant had, an accident that was, a workers' comp accident, and he had this separate claim under general municipal law, section 207C. And in that separate claim, the claimant got an additional site established. And then he raised that site in his comp claim and basically just argued, hey, it was established under GML 207C. It should now be added on to my comp claim. Now, the problem was that the claimant did not meet his burden of proof to prove causal relationship for this additional site in the comp claim. It wasn't cited on the C3. There was really no indication in the medical supporting the claim for the site. And the board said, we don't care that you established this under GML section 207C. That's a different standard that's, frankly, lower than the standard in comp. And it's not going to dictate how we're going to decide whether it should be established in this case. So basically, regardless of whether a claimant has an established site or accident, or anything that could have some sort of legal effect, or they might think could have a legal effect in their comp claim, they still have to go through the full rigmarole in the comp claim and prove and meet their burden of proving that, for example, here, an additional site that they're claiming was causally related to their accident. So, this is good for us in that it shows that, don't count yourself out on an issue just because it's been established somewhere else. It's maybe not the most common issue.
It's not uncommon, though, for 207 plans to be extremely generous in the way they're run, right? Like there's 207 plans can be run in such a way that basically anything that the injured law enforcement officer asks for, they get, right? There may have been actually no proceedings in the 207 matter whereby this body site was added to the claim. In fact, it may have just been accepted as part of the claim because the 207C matter is typically administratively addressed in-house much more quickly than the comp claim is. So the board was right to look at this and say that it's not clear at all that there's any sort of, there is parity of parties, right? And there is parity of issue, but the 207 standards are all premised upon the agreement between the parties that generates their 207C model, right? No two 207C systems are the same. One county or municipality may have one version, and then the agreement in the neighboring one is entirely different. Or and even if they were the same on paper, they could be administered entirely differently, right? One could be enforced to the T, and one could not be. So I'm glad that there's no equity being imposed in this case, because that would have been pretty terrible.
Agreed. All right, James, you want to tell us about this fraud decision in Southstow?
Oh yeah, so we're into the sexy cases, everybody. Fraud. This one is funny because this claimant is sort of hoisted by his own petard. After a claim is established, a while after, he raises concurrent employment and produces records of a home business. And unfortunately, fortunately for the employer in this case, he produces records that demonstrate his business continued to earn him income, and it appeared that he continued to be actively engaged in work for that business after his claim was established, after he had been found temporarily totally disabled, and after several occasions where he had told his physicians he was not working, So by attempting to enhance his benefits, this claimant literally handed the employer and carrier a fraud claim on a silver platter. And what was funny here is that the board decides to impose a mandatory penalty. I think they felt bad for this guy. They imposed a mandatory penalty for the periods where the claimant could demonstrate, or the claimant's proofs demonstrated that he was earning income. The employer managed to get a little bit of extra proof on their own, showing that the claimant was continuing to advertise the business even after the earnings from it seemed to taper off. And so they wanted a mandatory period that included not only the earnings, but also the advertising activity. And they wanted a discretionary lifetime ban. The board came back and said, we're not going to do a lifetime ban. That's not going to happen. By the way, we're also going to narrow the mandatory penalty down a little bit because we're not convinced that the activities of just advertising the business were sufficient to demonstrate that that should be a period during which the mandatory penalty should be encompassing. However, the third department came back in their decision and said, fine, we don't take issue with anything the board did here, but the board could have found the social media presence qualified as work, but we'll defer to it anyway. Right? So I'm like, okay, the third department's saying, well, we think this is probably wrong, but the standards of review are so low, you've met them. Congratulations. That's why the case is funny, right?
Right. I love this case, James. I had a similar case, and I think this helps solidify the finding of that case. And I think it's a significant one for people in the audience to keep an eye on, because I think it could happen more often than you might realize, and it can go under the radar a little bit. So I actually had a fraud win on this issue that's under appeal at the board panel level right now, where the claimant submitted evidence of concurrent employment, produced payroll records, testified on it, testified that the what she was doing to get that those wages was considered work. She testified to the hours that she worked and that she stopped. And then when we raised fraud later on, saying you were getting paid while getting benefits at total, the claimant backtracked and said, well, it's not work. I'm doing sort of home health aid services for a relative. And we were able to refute that statement based on the fact that the claimant had already testified that that it was work, and that, she worked a 9 to 5, weekends off, you name it, all that stuff that would sort of speak to the fact that it's work and not just some sort of stipend that was being received. And I'm just curious to see if potentially this decision gets cited. Now, in my case, there actually was a discretionary lifetime ban due to the amount of time that the claimant, committed the fraud, and the number of times that she either saw her own doctor or an IME doctor and denied that she was working. And basically the judge sort of found it disingenuous that the claimant was trying to now, after previously arguing that she was entitled to higher benefits based on work performed for a concurrent employer, was now trying to backtrack and state that actually it wasn't work. I shouldn't be found to have committed fraud. So yeah, it'll be interesting to see if this case gets cited.
Yeah, I suspect it will. Very high likelihood.
All right. So this next one's an interesting case with kind of a fun fact pattern, where the claimant self-published a novel while receiving comp, and the carrier argued for 114A fraud. And they won, but they wanted both an expanded mandatory penalty and a lifetime ban. Now, I think probably the most significant portion of this decision pertains to the mandatory penalty. And the carrier argued that the claimant published that it should be expanded to go back to the date of accident, and then actually to go beyond where the judge and the board ended the penalty. Now, the reason they said it should go back to the date of accident is because they argued that the claimant published the novel 10 months after the date of accident. So sort of implicitly, the claimant must have been writing the book at the time of the accident, and meaning that that mandatory penalty should cover all awards made from the date of accident on. They further argued that the claimant received goodwill from publishing the novel, warranting an expansion beyond the date that the penalty ended. However, there was an issue here with the fact that the carrier did not question the claimant on either issue at the fraud trial. They didn't ask the claimant when the claimant started writing the book, and they didn't ask any questions about any sort of goodwill received from publishing the book. And I think this is a really good example, James. Our practice model, which is to handle a case from start to finish and to really take the time to develop a strategy in a file, would be avoided. Really the issue here is that if this was something that we had been handling, we would have, come up with this argument and known to develop the record on that issue and to actually ask the claimant questions about it. Because, I think it is a reasonable assumption that the claimant was writing the book at the time of the date of accident. That wasn't an unreasonable argument to make that could be sort of implied. Why not just take a step and ask the claimant?
Well, and we can know that for sure, because the one thing we know from not just this case law update, but last year's and the years before, is the third department is going to defer to the board on fraud penalty issues, except mandatory penalties. And both the board and the third department look very carefully at the dates of the proofs. And if the mandatory penalty cannot align with an actual proof, then you cannot have a penalty for that period. And this is really that issue. And by the way, I'd like to read off. There's this guy has an author's page on Amazon. I'd like to read some of the titles. There are 7 titles. They're all currently unavailable, so he can't make any money off of them because he's got to collect his comp. But the first one is The Estranged, a dark psychological thriller novella. The next one is The Condemned, a dark psychological thriller. The Accursed, a dark psychological thriller, just in case we weren't sure what kind of book it was.
Is that actually in the title?
Yes. Yep.
Wow.
Oh, the last one is A Coward, a dark tragedy. So there we go.
I was an English major, and that's probably the first time that I've heard a book actually have the genre in the subtitle.
Yes. Well, I think that they're probably like Amazon published ebooks. Oh, you know what?
Yeah.
It says they're in paperback, so he must have had some kind of publisher, but they're unavailable. So I would challenge anyone out there in the audience to read it and report back to us at some later date on whether it was any good.
Yeah. All right, James, you want to tell us about what happened in Fuller?
Oh, okay. So we're going to talk about Fuller only because it talks about good practice. Fuller is the case whereby very smart, sophisticated, good-looking employer and their smart, sophisticated, good-looking attorneys decided that they wanted to challenge labor market on schedules. And they said, listen, the 2017 reform said that at the time of permanency, a claimant has to demonstrate attachment before they can get awards. And then once they do, they get their awards. Well, why can't we apply that same theory to schedules? Oh, and by the way, there's this definition that's been touted for a long time by the Appellate Division, and that's really enshrined in the statute, that says that a schedule loss of use award is only available to a claimant because it's deemed to be a current payment of presumed future lost wages secondary to the physical limitations imposed by the injury, right? The third department has said that on a dozen or so occasions. So what they wanted to do was to stop retired employees who took their regular pensions, who didn't leave work for any reason other than their age, from collecting a series of schedules afterwards, right? Because that happens a lot. Big public employers, they have good pensions, they have a series of minor injuries, they go out of work for their retirement, and then they start treating because now they have time. And then over the course of the first few years after they retire, they start to collect a series of large schedule awards that the employer is just being sucked dry. Now, the third department wimped out here. And I think it was intellectual laziness because they just said, listen, hey, the schedule doesn't actually pay somebody for any one particular week of lost time. So a demonstration that they're attached to the labor market at any one particular time doesn't seem like it would have any relevance to whether they can collect it. And it's not, and the award is, quote, independent of the time an employee actually loses from work, which is not true because guess what? We get credit the time they actually do lose from work against the ultimate schedule. So that seems to be somewhat of a disingenuous statement of the law. Now, this decision comes out from the third department. Leave to appeal is sought by the employer, and a slew of big employers move to intervene as amicus parties. So a lot of big, powerful, thoughtful, good employers in the state wanted this issue to be heard by the Court of Appeals. And amicus relief was granted to support the motion for leave, but the motion was denied. So leave was sought, amicus status was granted to several parties, and then the motion for leave was denied. So the issue may be dead, but is probably only dormant, because the folks that brought this up like this issue and think that they got short shrift on it. And I think it's going to get pushed again when a good case shows up. So I think we're going to see this pushed again. If you have a case where this fact pattern is in play, let us know, because we would be very interested in pursuing this issue again to try and get a better fact pattern up. And hopefully, now that the Court of Appeals has spanked the third department on some other cases, the third department might decide to look at this with some fresh eyes. And there are a lot of arguments to be made. So only some of them were made in this case. Brendan, tell us about McRae.
Yeah, so McRae is an interesting one involving work from home. So here there was an issue that I think many of you may actually have, or at least have a chance to run across, which is that the claimant was fine with returning to work, working from home during the pandemic, but when the employer called all employees back to the office after a lot of the restrictions relating to COVID were lifted, the claimant suddenly could not return to work. And the reason being here, which wasn't really discussed in the decision, at least not in much detail, even though it sort of turned on this issue, is that the claimant had moved to Florida. So I think this is actually a pretty common fact pattern post-COVID, and it's going to continue to be a common problem because a lot of companies have sort of shifted to hybrid work from home, in-office models that seem to be fairly fluid. You can see a scenario where an employer may have decided they were going to go full work from home post-COVID. They thought it was more cost-effective, and then decide, actually, this doesn't benefit us or doesn't work for us. We're going to ask people to return to the office. And here, the claimant then tried to make a claim for reduced earnings, even though she had moved to Florida. The issue was raised of voluntary withdrawal and causally related reduced earnings. And ultimately, we were able to win on this one by showing that the reason that the claimant can't return to work has nothing to do with her work accident. It's because she was working from home and she decided to move down to Florida. And just because she can't commute from Florida to the office after they called her back in doesn't mean that she has reduced earnings related to the injuries she suffered in her comp claim. So it's kind of a fun fact pattern. And I think it's one, like I said, that I think you'll see that you'll start to have, or you already do, have files with sort of a similar fact pattern. And I think, this case sort of solidifies that we have a very strong argument, for both voluntary withdrawal and against causally related reduced earnings being found.
And I think this case serves as a practice model for coloring facts. A lot of lawyers might tell you that facts that are strictly not related to an element of an issue probably shouldn't be developed. But I can tell you, and Brendan agrees, we talked about this earlier today, there were 3 decisions issued. There was a panel ruling, then an amended panel ruling, and a third department ruling. I think the word Florida is said like twice in all 3 of them. But it was clearly the most powerful factor because the board went out of its way to discredit the claimant's medical evidence about whether she could actually continue working or not once the employer said, we need you back in the office. And they basically said, we looked at the medical the claimant produced, and we considered the fact that the claimant had worked under restrictions for the employer in essentially a full duty status for a long time. and that there's no difference between what was going on before and what was going on after she produced this new medical evidence, which we just simply don't credit. You know, there were many ways that the board could have killed the claimant's entitlement to benefits in this case, but their choice to find voluntary removal was very clearly predicated on the fact that the only difference in this case was that the claimant had voluntarily moved herself out of the state and thereby made it impossible for her to return back to work. I think it was 1 or 2 days a week or something that they said they're going to make these people do. So this poor woman is sitting somewhere in Florida, having been totally beaten to death by Shannon. Thank you, Shannon. Not Brendan Shannon, Shannon Mackey. And I don't even know. Has she even reapplied for benefits, Shannon?
Yes, she has reapplied for benefits. I'm back in litigation with her right now. It's really fun and complex and complete BS, but I'm working on it.
All right. Outstanding.
We'll see another McRae decision. All right, James, you got Lasley.
Okay, so big headline is this is going to the Court of Appeals. We'll just lay out the issue here, which is if you request cross-examination at the first hearing following an issue becoming apparent in a case, you should be timely requesting cross-examination, right? That's your first opportunity to do so. Traditionally observed by board panel and appellate division rulings. But in this case, the panel and the third department went out of their way to suggest that while this employer had voluntarily authorized surgery, voluntarily made payments at the claimant's doctor's rates, and had otherwise been just wonderful and pleasant the whole way along, that their request to cross-examine the doctor at the first hearing following all of those activities was untimely, right? Because when the employer's counsel shows up to the hearing, they say, listen, 11 weeks of TTD is bullshit. And we think a lot of what the doctor says is nonsense. And we want to take that doctor's testimony. And everyone in the room knows, right? They know in their heart of hearts, especially claimant's lawyer, that if that doctor gets sworn in and starts to answer questions, that those 11 weeks of TTD are probably going to crumble, as are a bunch of other issues that may be pending at the time, right? But the judge says, no, if you wanted to do something about that, you should have done something sooner, right? And the third department and the board suggest, well, you should have filed an RFA or whatever. Nonsense. It's absolute nonsense. It's not what the regulation says. All the regulation says is that when an employer desires to produce a doctor for cross-examination, the board shall adjourn the case and allow the testimony to occur, right? So the Court of Appeals has taken this case, which is rare, right? The Court of Appeals takes 1, maybe 2 comp cases a year. And sua sponte, they directed oral arguments, which is also pretty rare. So the Court of Appeals, I'm knocking on wood, this is my interpretation of their behavior, looked at this file and said, what the hell is going on? Like, how is this not a timely request? How is this not a due process issue? Especially in light of the fact that, like, the board has issued all kinds of regulations that say, for example, we have to pay TTD even when there's no medical, and we have to do all kinds of other things, and we especially have to behave ourselves real good before the board has stepped in to make any rulings on the matter. So we also know that in another case that was being litigated at the same time, the board actually told us we couldn't schedule a deposition without a judge's order. And it turns out that the statute, during the process of its amendment many moons ago, actually contemplated that exact thing happening. So knock on wood, I think that this is going to end up being a pretty big spanking, and Melissa will be on her way up. It looks like it's scheduled so that it's going to be a fall term. Is that right, Melissa?
Sorry, I was on mute. Yeah, I think late fall, early winter.
Late fall, early winter. So we're going to have a viewing party.
Yeah, well, I have to win now. You're really building me up.
Yeah, we're going to have a viewing party. We're going to have popcorn and large sodas like you get at the movie theaters. And we're going to all watch Melissa live on the live stream. So there we go. Now you're really nervous. You're going to have to do really awesome. Next case.
All right. So next up is probably my favorite decision of the year, which is the decision in Panalan, which discusses the standard for proving causal relationship in an occupational disease claim. And this is a decision that we have been relying on constantly with OD claims in our office. Now, in this claim, basically it was found that the claimant did not meet his burden of proving causal relationship, where his medical did not go into enough detail as to how his job duties and the sort of motions and things that he did throughout his day contributed to causing the alleged OD claim. Now, if you read sort of the case more closely and get an idea of what the doctor said, the doctor made what the third department determined as mere general statements of job duties, sort of vague. Basically said, you'll see this a lot. Claimant engaged in repetitive lifting or repetitive hammering or anything like that. And what's important to take from this case is how to litigate an occupational disease file. And I'm going to mention another file that was decided at the same year that sort of speaks to like the other end of the spectrum. Now, the way to litigate an occupational disease claim is frequently to not get an IME, because more often than not, and this might start to change with this case law, but currently, more often than not, the doctor provides a very general theory as to how the claimant developed an occupational disease as a result of repetitive motions. It's usually claimant engaged in repetitive activities, claimant lifted all day. And what Panalan says is, no, you need to go through it activity by activity, time. The time needs to be discussed. So it should be 1 to 3 hours spent with overhead, lifting of tires, and 2 to 3 hours spent sitting at a desk, typing reports. And it really actually needs to go to that level of detail, weights lifted, things like that. And if it doesn't, it's not sufficient. And if you get an IME in a case like that, and the IME finds causal relationship, you're going to have a really hard time arguing that the claim should be disallowed, even if the IME didn't meet that same standard. You might win on an appeal, but you're making your life a lot harder. Now, there was another decision where basically the same facts. The doctor did not go into any detail as to, like what the job duties were in the report. But then when he testified, the doctor clearly had a legitimate understanding of the claimant's job duties, and that resulted in sort of the opposite result. So I just think this is a good, this is a great decision for our purposes, because it allows us, to really attack a lot of occupational disease claims solely on the medical. And it can be kind of nerve-wracking to waive an IME, but I think more often than not in an occupational disease claim, that's the proper strategy, and one that we should all be considering going forward.
Yeah, I can't disagree, Brendan. I thought the 2022 lineup was particularly compelling because Panalan and the other file line up so beautifully. And the only real difference was, we had two cases. They might as well be identical for all purposes, except that the doctor in the second file knew the claimant's job duties in detail, and the doctor in Panalan didn't know shit. And, a lot of instances when you're defending an OD, it's an established client, right? Attorney and client are familiar with each other. And so attorney understands what kind of job duties the claimant has. And the attorney also understands what kind of job the employer has, and has some prior knowledge of the doctors potentially that are engaged with claimants from that workplace. So it might be predictable. I thought this was an excellent decision too. It's one that we use a lot. We really don't like boilerplate case law if it can all be avoided. And this is one that it has been cited an awful lot. I've cited it myself.
And this is a lot like Fox and Yearwood, where judges aren't very receptive to it, but you should have success on appeal. And, just imagine this with Fox and Yearwood, you could have a lot of cases where the doctor both didn't review prior records, especially in an OD claim. There's frequently like prior issues or prior treatment notes where the doctor didn't review the prior treatment notes or prior diagnostics and didn't discuss the claimant's job duties in detail. You're now talking about having 2 third department decisions in your back pocket. And, even if it has to go to appeal because a judge won't listen to the argument, you should win on appeal.
It's a biggie. I like
All
it.
right. Why don't you tell us about Candela?
Oh God, I had to read Candela 3 times.
Same.
Yeah, it's pretty rough. So we have a Section 44 occupational disease claim. The employer who has employed and insured on the date of disablement is liable for the entire award, and then apportionment can be sought. In this case, what happened is Skanska USA might have been the employer who had the claimant on the books on the date of disablement. However, the claimant was not performing the work activities that caused, contributed, or otherwise led to the occupational disease that was being alleged. So what Skanska is saying is like, yeah, 44 says like theoretically we should be paying all of this and getting apportionment, but the functional result of the apportionment would be we end up paying 0 and everyone before us pays everything. So the board basically followed the statute and the practice that we're all familiar with, which is found Skanska liable with their carrier because they were the employer on the date of disablement. But the third department comes back and says, well, it also talks about the employment at the time of or following contraction of the compensable OD, not necessarily the date that disablement ensues. This is the concept that we would all understand to be contracture, which we see in 44A claims like dust disease claims. So that at this point, what they're saying is you might be able to set the DOD, but until you set the contracture date, the liable employer isn't properly found. So basically what they're saying is we've been doing it wrong for a long time. That's what I read this as saying. Disability when employed by a previous employer is not a prerequisite to finding contracture, but contra fide finding last year in the Kodak case, where they said latent disease contracture cases can't ever really have competent medical evidence, right? That was an asbestos case. So I'm not sure that the third department really understands what they're saying in this case or what it means for us. But it sounded to me like, after reading it several times, that we're going to be looking more like contracture arguments that we would see for dust disease cases. Your guess may be as good as mine at this point, audience.
All right, so next up we have Kaschi, which is a case where the claimant was a dentist and was a part owner of a dental practice and had a comp claim, got to the point of a claim for PPD benefits at the time of permanency, and the claimant was making a claim for reduced earnings, and she claimed that as a result of her injuries, she couldn't perform as many dental services as she used to be able to perform, and as a result, she was making less money. Now, what's really interesting with this case is that a CPA testified in the claim that the claimant's personal tax filings versus the dental practices showed some inconsistencies and suggested that basically the claimant's business was growing during the time that she alleged that it was shrinking related to her comp claim. So ultimately, while there could have even been a fraud finding in this case, the court and the board and the court affirmed that really the claimant just didn't make a credible claim for reduced earnings. And I would be curious. It's interesting to see that there was a CPA testifying in this case, and as to what brought that about, not entirely sure, but I think it's a sort of interesting and fun fact pattern that I think, James, you mentioned that you had a case sort of similar involving a dentist.
Yeah, and what struck me about it was the amount of money that the dentist was making for the minimal amount of work they were doing suggested to me at the time, this was eight years ago or so, it suggested to me that if they had simply spent the time that they would spend on their comp case trying to get an award, if they'd spent that performing dental services that they could perform, they would have made more money. But what was also interesting is our office does have some experience with complex RE cases where we've had to bring in forensic accountants to examine RE proofs, because tax returns, on Schedule Cs can be extremely complicated, and especially on a partnership with Schedule Ks, where there's sort of a business tax return for the partnership, but then individual tax returns for the individual partners that may reflect agreements about, profit sharing or equity values or whatever it is. And there is a ton of case law that talks about what the board will consider proper business deductions and what they won't, which doesn't necessarily align with what you can deduct based on IRS rules. So, like you can basically go in and rewrite their taxes, at least for the purpose of calculating an RE using the board's rules.
Yeah. So don't be afraid to think outside the box in retaining a CPA for something like that.
I would bet that the amount of money that was at stake made it well worth it.
Yeah.
Max rate for at least a year's worth of benefits. Yeah. So this is just, doesn't even matter what this case is about. We're showing you this case because I have said for years that every year there will be at least one, if not more, decisions from the third department saying that a claimant's reduced earnings, whether they're permanent or not, must be causally related to their disability. It is not a math issue. It is a burden of proof that rests on the claimant to establish that they're making less money, and they're making less money because of their injury, right? And it's their burden. This is another great case where the third department comes down and says, listen, it's the claimant's burden to demonstrate that the loss of wages or the loss of earning capacity is causally related to their disability. This is a case where this person leaves their job and goes to look for easier work, finds easier work, but can't demonstrate any relationship, right? He got basically per diem work, like reviewing papers for other people. So in this case, the claimant failed to meet the burden. And what do you know? For like the umpteen billionth time, claimant's counsel takes an appeal to the board and loses, and then takes an appeal to the third department and loses. And I guess one part of me says, okay, guys, come on, give it up. Like, can't you just remember that this is a law and counsel your clients accordingly? But on the other hand, we keep getting these great decisions. It just makes the string citation longer and longer and longer. I mean, we're pretty well to the point that an appeal on this issue, if it wasn't so fact specific, I would be asking for penalties, because it is, to quote the term of art that we use as lawyers, it is well settled. Happens every year.
All right. So, do you have something else, James?
Nope. I'm good.
Yeah. So we're getting a little long in the tooth here. So I'm just going to kind of roll through this one. So Grimaldi really just solidifies the decision from 2021. The board did not appeal the former ruling in Grimaldi. And it's just a reminder that where you have PPD and multiple claims, each carrier is liable for the portion of the award based upon the AWW, if higher, received by the claimant at the time of the latest injury. However, if the AWW was higher at the time of the first injury, the awards are calculated using the AWW at the time of each injury, subject to the apportionment percentage found to apply to that specific injury. And Grimaldi just sort of provided like more clarification that you apportion first. And then,
right.
Yeah.
That's the trick, apportion first, because the order of operations can mean that you end up paying functionally more money to the claimant than they should get. It's the intersection of like 6th grade math and workers' comp. And the problem is that lawyers don't become comp lawyers because they're good at math. And people typically don't become lawyers because they're good at math. And the judges are even worse. And at the same time, all the claimant's attorney says is, well, if you do the math that way, my client makes less money. And the judge is like, okay, well, what way makes them more money? Apparently, it's the way that the third department does not want it done.
Yeah.
The way it's supposed to be done is the way that we want it done. Less money moves as between both cases. So it's a big important point. It comes up a lot and it's confusing as hell.
It is confusing. All right, so James, you want to tell us about Waters?
Yeah, I just thought this was interesting because it was a bicycle case. Like I was thinking of Jeremy Clarkson and his hatred of cyclists. So this poor guy got hit by a bus while he's driving his car or driving his bike. And it's a unique case because it was reversed and remitted. It was a question of inside versus outside employment. The claimant had fixed employment locations that would cycle every 6 months. And in this case, it had cycled, but he was being asked to go to a slightly different place. So now the question is this a special errand? And he's now in what we would call like travel status on a special errand where he's covered? Or is he simply an inside employee who's in travel status and not covered, whether we apply portal to portal? What was interesting is special errand seems to have been an issue that may have been floating around in this, but had not been addressed below. And the third department just says, well, we can't disagree with you about this whole application of portal to portal thing where you disallow this case, but you didn't talk about special errand and we really think you should, so do it. And they literally kind of like, without making an order to that effect, they basically told the board, we suspect that this is compensable under the theory of special errand, and you should consider that, and then we'll look at the case again. Brendan and I scoured the records over the course of the week to see if this had been decided. And even though this decision came out in April, and even though it was reviewed by the full board in their April meeting, and it was accepted, there has been no subsequent issue of a decision by the board. So I was just curious to see if the panel from which this appeal was taken was going to try and stick it to the third department, or was actually going to establish the claim as a special errand. We'll let you know when we find out.
All right, so the next one is a biggie, not necessarily a goodie though. So this was the Johnson decision by the Court of Appeals, which addressed Genduso. And just as a reminder, Genduso is case law that we've used to basically get a credit against prior SLU. So if a claimant had a prior SLU for the left arm amounting to 20%, they get a new one in another accident for the same arm. If it doesn't exceed the 20% from the prior one, then, under Genduso, there would be no SLU award. Now in Johnson, they didn't all together reverse Genduso, but they sort of made it so that claimants can get around this. And what Johnson seems to stand for is basically that if the claimant can produce competent medical evidence, usually through both the report and the doctor's testimony, showing that the SLU in the second case is substantially different from the one in the first case. So, for example, like a situation where Johnson would hurt us would be you've got an elbow versus a shoulder SLU. So in the first claim, the claimant had a shoulder injury that resulted in SLU. The second claim, the claimant has an elbow that resulted in SLU award. Under the Genduso, as it was formally interpreted, it wouldn't matter because you get an SLU for the arm, not for the specific site. Now, if the doctor and the claimant's attorney do their work, they could technically have a stronger argument that Genduso should not apply. However, you'll see that the sort of the facts in the two cases that we discussed here, the doctors didn't necessarily always do the work. And there is still sort of a burden of proving that, that Genduso shouldn't apply. It's not actually laid out in that way, but it's sort of a matter of showing that there was a substantially different injury that should result in a different SLU. So not a great decision for our purposes, but there are ways to litigate this. And it's not just oh no, Genduso doesn't exist anymore, and now we don't get, that benefit. It's just we have to litigate it a little bit harder than we did beforehand.
Well, and if you don't panic and you read the decision closely, you get what you just told us, right? The burden's on the claimant's doctor. It's only really going to apply to the case where we're trying to take like an elbow schedule credit against a shoulder schedule, right? So it's still going Ganduso's still 100% on elbow, elbow, shoulder, shoulder, knee, knee, right? The question is if we take a hip and try and claim a prior hip should be credited against a current knee, the claimant's doctor has to separate out medically how those two things are distinct, right? So don't panic. We've still got this. I think Brendan, it's 107. We should just call it.
Okay.
I know we got a couple more cases that we want to talk about, but we're running through people's lunches. The blue case is really good. That we just the third department is trying to rewrite the guidelines. We have some ideas about how we're going to deal with that in the future, and I hope that the board is too. But let's talk about our case law update materials. As I said at the beginning of the presentation, our huge packet of materials that discusses every case will be available early next week. If you're interested in receiving a copy of it, please email myself or Brendan, and we will make sure you get put on the list. It's our intention that we're going to embed it in a page on our website, and we will be able to just send you a password where you can get direct access to it and download it directly from our site. So
yeah, if you want to email me, my email is B as in boy, Shannon, SHANNON at MadWC Defense.
Yep. And so I know we're over time, but there are a lot of people on here. Does anybody have any questions? I want to make sure anybody who has a question gets an opportunity to ask one, because there were a lot of cool cases this year. Do we allow participants to unmute themselves? Let's
Could also do it in the chat. I can't view the chat, James, so just let me know.
Okay, yeah, I'm looking at the chat right now. Yeah, if you have a question, throw it in the chat, or we can unmute you too.
They should be able to. Shannon did.
Okay. All right. Well, hearing nothing, I guess we'll call it. I know we're a little over time again. Very sorry, but this is our sort of nerdy passion. You want your comp lawyers to read this stuff and enjoy it. You want us to know it, and we want you to know it as well, because boy, it really can inform decisions about how you handle claims internally and about how you instruct your lawyers when we go out and go out into the field of battle and start fighting for you. So thank you all again, and everyone have a wonderful weekend.